Imagine this, you're sitting at your desk on a normal Tuesday afternoon, scrolling through emails, and suddenly, bam, a lawsuit lands in your inbox, and you don't even know the plaintiff's name. Yet somehow, before the ink on the complaint is dry, their legal team already knows where you bank, what companies you own, the equity in your home, and even what kind of car you drive. How? Because lawyers don't just sue, they hunt. They have a playbook, a step-by-step guide they use to track down, freeze, and strip away the assets of high net worth individuals just like you. And here's the scary part. Once they start, it's almost impossible to stop them unless you know how to break their playbook before they ever open it. I'm going to show you exactly how these predators think, the steps they take, and most importantly, how we shut them down before they ever touch your money. But first, if you're serious about protecting your wealth, you're in the right place. I'm the CEO of the Lawyers Limited Law Firm and Asset Protection Planners, and for 34 years, I've specialized in protecting clients from lawsuits, creditors, and divorce. For nearly 30 of those, I've been setting up Cook Islands Trusts. In fact, our firm has set up more Cook Islands Trusts than any firm in the world. So if you want insider secrets wealthy people use to stay lawsuit proof, hit that subscribe button now, because what you're about to hear isn't taught in law school, and it's not shared on CNBC. Let's start with the mindset of the predator. The contingency fee attorney, these lawyers are not paid by the hour. They get a percentage of whatever they can seize from you. And that means their motivation is simple. Find as many of your assets as possible and then figure out a way to pry them loose from you. Now here's the chilling part. They don't need to win the case outright to ruin you. They just need to make your life expensive, exhausting, and terrifying until you write a settlement check. A national study showed that over 95% of civil cases never make it to trial. Why? Because the process is designed to grind defendants down until they give up. And that brings us to the first move in the predator's playbook, locating your wealth. The first thing an opposing lawyer does isn't writing motions or drafting arguments, it's finding your money. They use a combination of tools, public record searches, your real estate deeds, mortgages, UCC1 filings, business registrations. They're all searchable. Own a $2 million condo in Miami? They'll find it. Have your name on an LLC? They'll pull the filings in seconds. Private investigators, yes, they hire investigators who specialize in asset searches. These professionals scour databases, court records, and even social media. You posted a photo on Instagram of your new yacht? Congratulations, now it's Exhibit A in their hunt. Credit reports and subpoenas. In discovery, they can subpoena banks, credit card companies, even business partners. Your entire financial footprint becomes a roadmap. So here's a real case. In California, a doctor lost a malpractice suit. The plaintiff's lawyer hired an investigator who found the doctor's home was owned free and clear. Within weeks, they recorded a lien forcing a fire sale refinance. The settlement? Nearly double the original claim. Now here's the cliffhanger. What happens once they've located your wealth? Because finding it is only step one. The real damage comes in step two. And most people never see it coming. Now, once a predator knows where your assets are, they don't just sit and wait. Their next move is to freeze them. Think about it like hunting a deer. It's not enough to spot it in the woods. You've got to trap it so it can't escape legally. This happens through prejudgment remedies. In some states, a judge can freeze your bank accounts before you've even lost the case. Now imagine logging into your online banking and seeing a zero balance, not because you spent the money, but because the court locked it up. Lis pendens filings. In legal speak, that's a Latin phrase that means pending lawsuits. If you own real estate, a lis pendens can cloud your title, making it impossible to sell or refinance. Your $1 million property, suddenly radioactive. Charging orders, if you own an interest in an LLC, courts can grant charging orders that redirect distributions straight to the creditor. Now here's the kicker. These moves are often granted ex parte, meaning without even being present in the court to defend yourself. In fact, one of my clients, a successful contractor, discovered this the hard way. He was sued by a former partner, and before he could even hire me, the plaintiff had slapped Liz pendants on all 3 of his properties, instantly blocking a refinance he needed to keep cash flow alive. By the time he called, the trap had already sprung. Okay, so how do you stop predators from freezing your assets? That's where we outsmart them, and the key move comes in step 3. So here we are, step 3, the squeeze. Now, once assets are frozen, the pressure campaign begins. Lawyers know the psychology of money. They don't need to win. They just need you to feel like you're bleeding out until you cave. They file motions to compel, demand documents, drag out depositions. They'll demand years of tax returns, personal emails, even travel receipts. Their goal? To overwhelm you with legal bills and embarrassment. And here's where the secret weapon comes in: forensic accountants. Now, these financial detectives dig into every corner of your life. They trace money flows, uncover hidden accounts, and even use lifestyle audits. If your reported income doesn't match your vacations or your cars, they pounce. Case study. In New York, a wealthy entrepreneur tried hiding assets by putting them under his girlfriend's name. The forensic team noticed his spending patterns didn't match his reported income, and within weeks, they subpoenaed her accounts, proved commingling, and froze $3 million. So what's the counter move? How do you make their playbook useless? It all comes down to one word: jurisdiction. The counter playbook. Here's the truth. Lawsuits aren't won and lost just on facts, but on where your assets live. In the United States, judges can freeze accounts, seize properties, and enforce judgments with a few strokes of a pen. But what happens if your wealth lives in a legal environment that doesn't answer to U.S. judges? And that's where we turn the playbook upside down. We use Cook Islands trusts with a Cook Islands LLC nested inside. Here's how it works. You're the initial manager of the LLC when life is calm. You control your investments, bank accounts, even real estate through this structure. But when a lawsuit strikes, our licensed, bonded trustee company law firm in the Cook Islands, we've been working there for 30 years, steps in not to take your money, but to protect it. They follow your instructions. They're highly regulated, but when under legal attack, they have the legal duty to say no to U.S. court orders. So why does this work? Because the Cook Islands has some of the strongest asset protection laws in the world. Their courts do not recognize U.S. judgments. So if a predator lawyer wants to pursue assets there, they must relitigate the entire case in the Cook Islands under Cook Islands law with a burden of proof on them. And here's the kicker. The statute of limitations on fraudulent transfer in the Cook Islands is just 1 to 2 years, meaning if you set up the trust before trouble starts, after 2 years, it's locked down. Even if somebody else sues you later, it's too late. Now, your assets are protected right away. There's a small window to challenge it, but we've never seen anybody win that challenge, so it protects your assets immediately. One predatory lawyer told me, off the record, if I see assets in a Cook Islands trust, I don't even bother. It's a waste of time. So here's a case study. Let me give you a real life example. A client of ours, a Florida real estate developer, faced a $12 million lawsuit from investors when a project soured. Now, the plaintiff's lawyers followed the playbook. They dug through his properties, filed Liz pendants, and tried to freeze his bank accounts. But here's what they didn't know. Years earlier, we had helped him set up a Cook Islands trust with a Cook Islands LLC holding liens against his properties. So when the predators moved, they hit a wall. We got third-party lenders to purchase the mortgages and place the proceeds in his offshore trust. So the equity was already stripped out through the liens payable to the offshore LLC and then purchased by the third-party lender. The bank accounts were under Cook Islands protection. U.S. judges issued orders, but in the Cook Islands, those orders weren't worth the paper they're written on. The plaintiff's attorneys eventually walked away. Our client kept his properties, his accounts, and most importantly is peace of mind. Okay, so now you know the predator's playbook. Step 1, they find your assets. Step 2, they freeze them. Step 3, they squeeze until you break. But you also know the counter playbook. Move your assets into a jurisdiction where their tricks don't work. And that's exactly what we do every day. We've been protecting clients for 34 years. I've been setting up Cook Islands Trusts for nearly 30 years, and our firm has set up more Cook Islands Trusts than any firm in the world. So if you're serious about making yourself lawsuit-proof, feel free to visit assetprotectionplanners.com. You get a lot of free information there. And if you're interested, you're serious and not just curious, and you have at least $500,000 to protect, fill out a form, schedule a free consultation, because here's the reality. The predators are out there. They're hunting, but you don't have to be the prey. And remember, the best time to set this up is before the lawsuit lands. Once the hunt begins, you may already be too late. So don't wait, protect yourself now.